Jill. I believe Collett is going to start us off.
Yes, I had a problem getting started. But good afternoon, everyone. I'm Collett Small, and I'll be presenting on this segment along with my esteemed colleague, Melissa Bardhardt. And like many of the presenters here today, I too consider Arlene a dear friend. And to say that she's missed is an understatement. In preparing for my presentation, a few of Arlene's other friends, attorney Amy Fanslaw and attorney Travis Fincham, shared some of their special needs trust materials with me that I incorporated into my materials today to make sure you're getting cutting edge information. Now, we just heard from Michelle and Jill about planning for a child who's turning 18 from the perspective of maintaining their independence, by using less restrictive alternatives, if those are in fact available, along with utilizing guardian advocates and guardianships when those are more appropriate. Now, Melissa and I are turning to another stage of planning. We will be discussing special needs trust and how those trusts are administered. We will attempt to reserve 10 to 15 minutes at the end for questions, so please send us those questions via chat. For our presentation, we will be using a scenario about the Smith family. So without further ado, let me introduce you to the Smiths. We have parents, Mr. Smith and Mrs. Smith. Mr. Smith is 60 years old and Mrs. Smith is 58, and they've been married for 25 years. They have one child, a daughter, Anne, and she is going to be 18 later this year. She was born with cerebral palsy, and she's also on the autism spectrum. Anna uses ambulatory assistance, and she could do most of her activities for daily living on her own. But she needs some prompting and support, and she also faces a little bit of difficulty with focusing. The Smiths are currently on the wait list for services through the Agency for Persons with Disability. And they have been told they have about another year or two left on the wait list. Anne is still in school. She's currently in the 10th grade at the Academy at American Heritage, and she attends for free because Mrs. Smith works at the school. Anne is not on the McKay Scholarship, and she will stay in school through age 22. Anne resides at home with her family, and there are no immediate plans for any changes to that living situation. And Mr. and Mrs. Smith, they recently met with Michelle Kenny and Jill Ginsburg, who you just heard from, about planning for when Anne turns 18. And they're still in discussions on whether or not they want to use any of those lesser restrictive alternatives that Michelle and Jill talked about. They're considering whether they want to use a durable power of attorney or a healthcare surrogate, or if they want to go the route of a guardian advocate or consider a full guardianship. Now, both parents work. Mom is a teacher at American Heritage, and dad is a professor at a local university, and he plans to retire when he turns 67. Mrs. Smith is planning to retire about the same time that her husband retires, so she'll be 65 at the time that she retires, if her plans hold up, and she may consider leaving her current job after Anne graduates when Anne turns 22. So, this poses some questions. How will all this impact their situation? What about Anne and her insurance? The mom may want to get a paid caregiver for Anne after Anne leaves school. The family is currently utilizing the insurance for Mr. Smith through his job at the university. And the parents pay an additional for Anne, they pay for therapies and all her living expenses, which comes to approximately $40,000 per year. And she's not on any benefits due to deeming issues. The parents also have a second to die policy for $500,000, and Anne is a designated beneficiary of that policy. There's also a policy through Mr. Smith's work and also one through Mrs. Smith's job for one time each person's salary while they're working with each other as a beneficiary. And then Anne would be the successor beneficiary to that, or the contingent beneficiary. So Mrs. Smith doesn't have a long-term care policy, but Mr. Smith has one that will cover approximately or $250,000 of care in home or care in a nursing home. And the Smiths heard about the ABLE Act and they're wondering if they need a special need trust or can they just use an ABLE account instead of a special needs trust. They do have planning documents, although their plan is to have Mrs. Smith's sister as a successor power of attorney, healthcare surrogate, guardian advocate, or guardian, so whatever the route they go. And Mrs. Smith's sister is 60 years old, so she's slightly older than Mrs. Smith, and she resides in California. So here comes the Smiths to Melissa and I, and they are seeking some advice.
Yes, thank you, Collett. What we wanted to do here is show you this family scenario so that it will hopefully be relatable to you. And as we continue going on here and talking about what a special needs trust is, which is basically an instrument that allows you to still qualify for what are called means-based benefits that I will be describing a little bit later on after Collett goes through the next portion. So Collett, can you start off by telling us about the different types of special needs trusts and why that is an important first step to help Anne's parents plan appropriately?
Sure. Before I get there, though, I want to explain that a trust is similar to a contract or an agreement of what you wish for or what you intend, in this case for Anne, and how that will be accomplished by a trustee. And Melissa will talk a little bit more about that portion with the trustee later on. But first, I want to talk about a third-party supplemental, it's another word, special needs care trust, and how that differs from other special needs trusts, because there are different types out there. So I'll attempt to define and clarify and talk about the differences. So the third-party special needs trust, and these are commonly used by persons that are planning in advance for loved ones with a special need. And they're created and funded by third parties. So they're individuals other than the person living with a disability or the person's spouse. So typically it's a parent, it's a grandparent. In this case, it would be Anne's parents, Mr. and Mrs. Smith. Then there are also first party special needs trusts. These contain the assets of the beneficiary that's living with a disability. So in this case, Anne. And these are sole benefit trust, and it includes a payback provision to Medicaid for states that pay for Anne's care. So one of the questions that we think about, would Anne maybe, from the scenario we discussed earlier, possibly need a first party trust if we don't do any planning? Because remember now, she's a beneficiary that's designated on the life insurance policy. And do we want to avoid that? And if so, how do we avoid that here for Anne? So it's something to keep in mind. Another type of special needs trust is a trigger special needs trust. And this is a type of trust, and it morphs as it's needed. It could be a first party trust or it could be a third party trust. And these are typically used when a person who's living with disability may not need Social Security or Medicaid right away, but they might need it in the future. And this trust is set up that upon a triggering event, it evolves into a special needs trust. So it's important to have the disability established. So when you're drafting, you want to make sure you draft and include a standby provision that's stated within the trust, so that if there's ever a need for future benefits, the intent is right there in the document for purposes of modification or decanting. Then we also have pool trust. This is a trust that contains the assets of an individual who is disabled and has to meet several conditions. One is the trust needs to be established and managed by a nonprofit organization. And a separate account is maintained for each beneficiary of the trust. But for purpose of investments and managing of the funds, the trust pools all these accounts together. The accounts in the trust are then established solely for the benefit of the individuals who are disabled. And it's established by the parent, the grandparent, could be a legal guardian of the individual themselves, or by a court. And to the extent that there are monies left in the beneficiary's account upon the death of the beneficiary, and that's not retained for expenses by the trust then pays the state from these remaining amounts an amount that's equal to what was paid for medical assistance on behalf of the beneficiary. Important to know that special needs trust may also be established by a will, and it's treated like a third-party special needs trust, which I discussed earlier. So it does not require that Medicaid payback provision to the state. All right, so that was quite a bit on trust. I just want to go through the distinction again through first-party and third-party trust, and then I'd like to talk a little bit about things that I, as someone who drafts these types of trusts, includes in my drafting to make the trust do what it's intended to do. So the first party trust, the assets remain, the assets in the special needs trust are established by a disabled beneficiary, or they belong to the disabled beneficiary, and there must be a payback to the state of any benefits that are paid to the beneficiary by the state or on behalf of the beneficiary by the state for a public assistance program, mostly Medicaid in our case. The trust must be irrevocable, must be the funds of the person with a disability. And typically these funds, we see them coming from inheritance or personal injury awards, earnings or savings of that individual. And most attorneys, including myself, would advise trustees that because we have this payback provision where upon the passing of the beneficiary, there is a payback to the state, we think you should distribute liberally during the lifetime of the beneficiary and plan to have as little, if any, remaining assets. There is an age limitation on first party special needs trust, and that's age 16. So those have to be created and funded before age 65, created and funded before 65. Okay, and then a third party, so compare all of that now to the third party trust. These do not have the Medicaid payback provisions because these are not the assets of the disabled individual, where it wasn't, it was given to them. So there's no sole benefit required. So in this case, the other parties can benefit. This trust can benefit other individual, not just the beneficiary who's living with a disability. So trustees, and because of this, the trustees of these trusts should continue to consider the future needs of the remainder beneficiaries, particularly if the controlling instrument, that means the trust document itself, directs a trustee to do that. And the neat thing about third-party special needs trust, you could create them now and you could fund it now, or you could fund it later. You could write a special needs trust within a will, or you could write it within a revocable living trust. And this is often helpful with regard to planning for the probating of a will, in this case with Mr. and Mrs. Smith, or if they have a revocable living trust, and planning for incapacity, incorporating the special needs trust provisions for ongoing expenses that can be paid to Anne. We talked earlier, they currently pay about $40,000 annually in expenses for her, including therapies and other expenses. And after they pass, there might be a lap as there is going to be a period of time when the trust is going to be settling and their estate is going to be settling. So we want to consider that. So in addition, the trust gets approved by Social Security and or Medicaid, and at least we send them a trust notice. And Mr. and Mrs. Smith would have that peace of mind knowing that the trust has been approved during their lifetime. So more attorneys are leaning in the direction of making sure that this is done. Okay, just want to go over some key things that I should be or must be and what should not be in your special needs trust. Okay, so what must be in the special needs trust, and I'm talking about the first party special needs trust in particular here, is we must have a provision that the settlor or the grantor is, or they must be, the people who create this trust must be either the individual themselves, a grandparent, a parent, a guardian of the person living with a disability, or the court. The trust must include a statement that the trust is irrevocable. The beneficiary has to be someone that has a disability. There must be a statement that the trust is for the sole benefit of the disabled beneficiary. And they must include a provision that the trust contains only the assets of the disabled beneficiary. And there is a required Medicaid payback to all states. And when I say all states, I'm just literally meaning all states. So it can't just be Florida. It's any states that have rendered benefits for the disabled beneficiary. So that's the must. What should a good idea to include in your first party trust is the ability of, or your special needs trust is the ability to amend the trust if there's a problem or if there's later a change in the law. The only thing, this ability to amend the trust cannot be by the beneficiary, but by the trustee. And then the trustees has to have power to administer the trust according to Florida law or any state law. And we need a defined remainder beneficiary after the Medicaid payback, just in case there is money left after the beneficiary passes away, then who would be the beneficiary after the state that you've done the state payback and there's still some funds left. We need to make sure we've named someone who's a successor to the state. We want to make sure that the trust includes the ability for the trustee to pay for food and shelter in the trustee's sole discussion. We'll talk some more about that later, but that's really important. And should include a provision to pay for, that they have the ability to pay for medical insurance or medical expenses. And I think it's a great idea to have the trustee have the ability to fund an ABLE account if the beneficiary qualifies for that. And Melissa will be talking some more about ABLE account a little bit later on as well. What should not be in your special needs trust? If it's a first party trust, the payback should not just be to Florida Medicaid, but as I mentioned before, should be to the Medicaid of all of the states. So any state that have paid out benefit, that's important for the success of the trust. Also, the beneficiary should not have the ability to direct payments from the trust. The beneficiary should not have the ability to terminate the trust. The beneficiary should never be named as a trustee. And there should not be, the trust itself should not allow the use of funds in the trust, in the first party trust, for any person's benefit other than the beneficiary during the beneficiary's lifetime. And that again is the sole benefit issue that I talked about earlier. So now I have discussed the background for what a special needs trust is and the types of special needs trust and some of the mechanics that are involved in drafting. So we could start now looking into how the Smith family can help structure a plan that will work for their family and make things flexible for Anne. So Melissa at this point is going to review the roles under the trust so that Mr. and Mrs. Smith have a better understanding of who they wish to name.
Sure. Thanks, Collett. Before I go into that, I just wanted to mention that I'm going to be focusing on, and Collett for the rest of the presentation, on really the third party special needs trust scenario. And that means that there is no payback provision in that case. And the reason why Collett went into detail on the first party trust is because, as we mentioned earlier, right now the beneficiary designation on the insurance that's left for Anne is being paid directly to her. So the point of today's presentation is also to explain to you that by going to an attorney that is well versed in special needs trust planning, they're going to be able to look at things from a holistic perspective, and will realize that rather than having to have that need in the future for Anne because of that payback provision, they can merely change the beneficiary designation to a third-party special needs trust. I also just wanted to take a moment just to describe what an ABLE Act account is, since we've mentioned it a few times already, and that'll be used a little bit more as I go through parts of the presentation. So ABLE stands for Achieving a Better Life Experience Act. It was passed at the end of 2014. It is an account and not a special needs trust, but the two can really work well together to maximize the flexibility for your child, who is also known as a beneficiary under the trust, as well as, just making sure that from a living arrangement perspective, where Anne is going to be living, and the ease of ability for her to get access to funds without necessarily having to go to a trustee. So it's a separate account. And that account is a tax exempt account. It's also, many of you have heard of a 529 plan for saving for education. This is 529A that was added to the Internal Revenue Code. And basically it allows an individual to have assets in there up to $100,000 and still qualify for supplemental security income benefits, which I'll go through in a moment, as well as Medicaid up to even a much higher number. But it's going to take a while for them to get there. There is a payback provision in the ABLE Act account as well. The state of Florida has said they're not going to go after those funds unless there's a beneficiary that passes over the age of 55, and there's a different rule that applies to that. So I don't want to go into all the nitty-gritty about that, but I do want to let you know that those accounts can be used for anything that's considered a qualified disability expense. And since we've already talked about how Anne's parents are paying those $40,000 of expenses for her and that she's living in that home, some of those, such as housing, basic living expenses, general health and well-being, transportation, educational needs, all of those are qualified disability expenses. And so it becomes important to understand that from a special needs trust, you can also do transfers into an ABLE Act account. And right now there's a cap on the amount that you can put into an ABLE Act account per year from any source. So it can be from the person, him or herself, or it can be from a third party. So it's a little bit different. And that's why I wanted to mention it here, because it's an account. It is not a special needs trust. So there's no differentiation on where the money is coming from for the ABLE Act account. And that's why they can put the payback provision in there, because that's under 529A. So it has nothing to do with the special needs trust laws related to the first party trust. And you'll see how that kind of works together when we go through a couple examples. So now I'm going to step back again into what we were talking about and just going through some of the terminology and some of the roles that exist, similar to the durable power of attorney for property and the healthcare surrogate, the guardian advocate or the guardian. There's people that are specifically designated to take on those roles on behalf of that individual who designates them in those cases. Here, it's called a grantor or settler that creates that contract or the roadmap for the trustee who's appointed, again, under the document by that settler or grantor. And here that's Mr. and Mrs. Smith, and they could each do one, or they could do one jointly. There's many different ways to accomplish that, as Collett alluded to during her part there. And many people, as she mentioned, are creating them now, funding it with a little bit of money so that you can get the approval of Medicaid and Social Security in advance and know your document is a good one, and then have the flexibility for the amendment provision for any changes that have to come in the future. So by doing that, we have the settler or grantor, again, Mr. and Mrs. Smith. They're creating that roadmap. Really, what is their intent under that document? What do they want to see accomplished for Anne? Also, concurrent with that, the parent should also be helping develop a plan from the personal side. So when we talk about the terms of the trust, and we're going to get to that in just a few moments, the terms of the trust, you have to have certain things in there that are going to be legal wording or legalese, as we like to call it. But I always like to make sure that families understand why that language is there. And so we're going to go through a couple of examples here with Mr. and Mrs. Smith and Anne to explain that in a few moments. But it's basically you putting your intent there as to what you want to have happen or not have happen. But at the same time, like I said, you're going to be developing potentially a letter of intent or something of that nature where you're writing down what are those specific nuances for Anne. Anne's living at home with you. Let's say it's Anne is your child, to the participants on this call here. You know what's going on in your child's life on a day-to-day basis. Sometimes you have the ability to write that down, and I highly suggest that you start doing that, because whoever your trustee is that's designated under your document is going to need to know that information. You'd want them to know that information. If your child likes to have hot fudge sundae every Sunday at 4 o'clock, that's something that the trustee would never know unless you put that in writing. And that could be something that Anne wants right now because she's also on the autism spectrum. What's important in that case is the structure of that person's day. And Anne, in this case, if the parents pass away, whether it's one or after the second to die, that's going to be very emotional for her, like it would be for anybody, but even more so because her complete world is going to be turned upside down and that structure is going to be gone. So having that information shared is really, really key. And that's why determining also who the trustee would be. So the trustee is supposed to have, is like the manager of the trust, basically. And they go according to your wishes, the four corners of the document and what is written there, along with understanding what's going on in the personal world for Anne as well. Both are important things. And their duties are to Anne and only to Anne as the primary beneficiary of your trust document. And then, there's different people that can play the role as a trustee. It can be an individual, it can be a corporate trustee, it can be a pooled trust trustee, as was mentioned. Those are managed by not-for-profit organizations. And it really can be anybody that you want to name that you trust, but you do have to have a succession plan in the document for those individuals also. So it's always good to have that backup there that might be more available for years to come. I've already mentioned that Anne is the beneficiary and she doesn't hold legal title to the property in the trust. Everything would be retitled in the name of the trust. So the trustee has the legal title to it because of that. But in this instance, again, she still retains an equitable interest as a beneficiary. But basically, again, all of our duties are to Anne in this instance. There are other roles that can be played as well. And one such role that you might hear of is called a trust advisor. So sometimes there's even trust advisory committees that are put into documents. And really, I see a trust advisor role, somebody that's personally involved with Anne. Maybe the sister of Mrs. Smith here, who's going to be ultimately appointed as successor guardian, if there is a guardianship, or a successor agent under a power of attorney or healthcare surrogate. Or maybe some other people that are involved in Anne's life. Maybe she attends a place like Anne Stork Center where they have some additional programs so that people are very, very familiar with Anne already, that you're going to also write into that letter of intent. But you can also write those people into the document to have that role to advise the trustee if there's any issues that they need to be aware of that they may not be aware of because of the day-to-day needs that they may not be fully familiar with. And then there's also a trust protector. So trust protectors really came about because if you have a trust that's done under a will, as was mentioned earlier, and some even during lifetime trusts that are revocable or irrevocable in a third party context, they may not be able to be amended by the grantor or the settlor or Mr. and Mrs. Smith in this case, right? Or if they're deceased, obviously they can't amend the document. So we already talked about that amendment provision being out there, and sometimes people use a trust protector to do that. Oftentimes it was put in there for changes in tax laws, but us in the elder law arena, we realized that this could also be used for if there's changes in benefits rules or regulations, which oftentimes there are. So having an amendment provision in there that allows for those changes just allows the document to remain fluid. So those are really the different types of roles that can be played. Another reason for a trust protector, and many parents would want this in their documents, is that it allows a trust protector to change the trustee with or without cause. And other people can also have that power, but oftentimes it's given to the trust protector. So that let's say there is a corporate trustee that's mentioned, and there's people that the family has been working with before they passed away, since then they are no longer at that same corporate trustee location and they want to move with that person, they can do that easily. Or if Mrs. Smith's sister in this instance doesn't feel that the current trustee is acting appropriately, or if there's an individual name without a successor named and you need to have a new trustee appointed, period, that would be a good way to do it where you don't necessarily have to go back to court, which is more costly and usually more time consuming as well. So it's just an easy way to keep that document flexible once again. So now that I've gone through some of the different roles and we've talked about the trust itself, again, the whole purpose of a special needs trust is to allow an individual to continue um, being, I don't know, I see, can everybody hear me still? Can you just give me a thumbs up, Collett, if you can hear me still? Okay, thank you. So I just lost my train of thought. Sorry about that. I call it mental pause. Hopefully some people are laughing at that one. I was just starting to say, I saw some things changing on the screen, so I apologize. It just switched my brain off there for a moment. So I was talking about the whole purpose of the Special Needs Trust is so that the individual can continue qualifying or begin to qualify for those means-based government benefits. So before we go in any further into the conversation about the trust and how it operates or the terms of the trust, I want to talk to you a little bit about government benefits. And you've heard me say means-based benefits a couple times. The whole trust is exempt when you're looking at means-based government benefits, and all that the definition of that is that they look at your assets or they look at your income and qualifying for certain benefits. Okay. Before I get into the means-based benefits, I want to talk about non-means-based benefits and just really one thing in particular that is a non-means-based benefit that might apply to Anne in this situation in the not too distant future. So non-means-based benefits for all of us that we're working, we're paying into the system, we're hoping to get our Social Security check when we reach retirement age, and then Medicare at the age of 65, of course. And we have to work for 40 quarters, generally speaking. There's always exceptions to all of these rules, especially if you have a child that was, let's say, in an accident at a young age. There's a different level of work that person has, usually only about 1.5 years worth of work, and they could still qualify for Social Security disability under their own work history. So we're hoping to get our Social Security benefit, and then if I became disabled while I'm working, I can then apply for Social Security disability benefits as well. So that's part of what we've paid into the system for. What a lot of people don't know, though, is that when you get Social Security disability, it's also tied to Medicare, not Medicaid, but Medicare. 2 years, 24 months after your eligibility for Social Security disability, you get Medicare. So why is that important for you to know here? If you have a parent that has retired, become disabled, or has passed away, and in this case, Anne is about to turn 18, so I'm just going to talk about when you're over the age of 18, and that disability for your child began before the age of 22, then you can apply for a benefit called Dependent Adult Child Benefit. Sometimes it's also just referred to as a child dependent benefit, but we call it Dependent Adult Child Benefit under the parent's work history. And the child can receive approximately 50 to 75% of the adult parent's benefit. And usually when you're looking at a family as a whole, it's 130 to 150% of the highest wage earners benefit that you can get as a maximum between the two wage earners in the family here at that point in time. So we talked about, and that also is important to think about. Sometimes families want to work and, you know, they obviously want to get the additional Social Security. And I'm sure a lot of you know that if you take your Social Security as early as 62, there's sometimes a 30% penalty. So the amount is reduced by about 30% if you start at the age of 62. But as you get closer to your full age of retirement, and here it would be 67 for both Mr. and Mrs. Smith, and he's planning to retire at 67, but she's thinking about retiring around the age of 65. But maybe she's going to decide to retire a little bit earlier after learning about the DAC benefit and after looking at their financial circumstances to see what will be best for them as the parents, but as well as for Anne in this instance. So learning about the DAC benefit is important. And also, when Anne is eligible for the DAC benefit, which they can apply for immediately upon that retirement or the disability or when the parent passes away, she also 24 months later will receive the Medicare benefit, which is very, very important. Now you might be asking yourselves, well, can Medicare, that doesn't necessarily pay for everything. A lot of times there's 20% that isn't paid for, right? That Medicare covers. So Medicaid then is always the payer of last resort. but a person could still get the Medicaid and have that kind of as their supplement to their Medicare. So that's one other type of means-based benefit that I'm going to get into in just a moment. So that's the non-means-based benefit. And all that means, again, is you can have $1 million in the bank, and that's not going to matter. You would still qualify for those non-means-based benefits. So let's talk about right now, since they're not retired yet, what Anne's options are. So when she turns 18, the family should be taking her to apply for SSI, Supplemental Security Income, which in Florida and 36 states in the United States is tied to Medicaid. Actually, I saw that we just passed that, although it hasn't passed the Senate yet. I think it passed the House, about the 51st state being DC. That may come to fruition this year, who knows? Anyway, getting back to the means-based benefits, in Florida, it's important to understand that in any state, and when we're looking at California possibly being a place where Anne may have to move if Mrs. Smith's sister ends up taking over things, if that's in her best interest to move to California. California is not an SSI Medicaid related state. So what that means in Florida, though, for purposes of today's conversation, is that Medicaid can't make their rules more restrictive than Social Security. And that becomes important later on when we talk about the trust terms, because I am going to mention something to you now. It's called Programs Operations Manual System. That is what we look at I currently work for a company that acts as a trustee, and we look at that, and attorneys look at that also when they're doing the drafting of the documents, because they'll often incorporate certain things regarding that, POMS for short. That's kind of a roadmap for us and for people who are acting as trustee to know what they can and cannot do. How is that going to impact a certain benefit? So SSI is for individuals that have a disability, just like Social Security disability is for people with a disability as well. So there's a medical determination for Social Security disability, but when you're talking about Supplemental Security Income, or SSI for short, it's the financial criteria, because you have to qualify and not have assets for typically more than $2,000 or less, an ABLE Act account or a special needs trust. Those are exempt, remember, but typically speaking, 2,000 or less in assets, a house, a car, and very little else. So that's why we couple all these different things together, like I was explaining earlier. So the beauty of getting on your SSI again, and it's capped at $794 a month. That's what the government says you can live off of for your food and shelter needs. But then you also get the health component, the health insurance component through the Medicaid. And $1 of SSI is what gives you the Medicaid in Florida. And that's important, again, for that tying in of those benefits. So having a special needs trust, you are allowed to qualify for those benefits. So when Amy becomes eligible for that, that's going to be great. We don't want to have anything in her name other than that 2,000 or less, an ABLE Act account, and maybe a special needs trust as well. And we'll see in a moment how those can all be coupled together for that. There's also Medicaid waivers, and this is important because not everybody here is possibly, I know this presentation is for individuals living with developmental disabilities. However, there might also be some people on this call that have, mental health needs for their child, or something that doesn't necessarily fall in the category of a developmental disability. So there are different types of what we call waivers. In Florida, it's called the iBudget waiver for people with developmental disabilities. Before, when Michelle Kenny went through that listing of what is considered a developmental disability, it's extremely limited on certain diagnoses that are actually in the statute. So if you're not within those diagnoses, you're typically not going to be considered to be developmentally disabled. And many things can fall into there. There's also, pervasive disability not otherwise specified that may not fall into any of those categories. So it's good to be aware that there's other types of waivers also. And this is the only one where she got on the waiting list early here, Anne did, and hopefully she's going to get off in a year or two, because the waiting list is about 5 to 7 years, if not longer, in certain periods of time. So getting that individual on that waiting list is extremely important. It's also one of the only benefits where they don't look at the parent's assets or income. and the child can still qualify. So that's why in this case, they applied even earlier than, when we're having this conversation today. So the waivers are also called home and community-based service waivers. Sometimes they're also referred to just as long-term care. The important thing to understand is that there's different asset and income limitations for when you're talking about long-term care benefits as well. And the last one is the QMB benefit that I want to mention also, because a lot of people aren't aware of it. And that's a qualified Medicare beneficiary benefit. And what that is a moment ago, I told you that Medicare doesn't cover everything. Sometimes people are not on SSI and Medicaid, but they're just getting either their own Social Security disability or they're getting that DAC benefit, and now they've qualified for the Medicare. So what does qualified Medicare beneficiary benefit mean? It's actually a Medicaid benefit, even though it has Medicare in the words to describe, the title of it. But it is a Medicaid benefit. So you actually apply for it through My Access Florida. Whereas for SSI, I failed to mention, you only have to apply through Social Security because Medicaid is automatically tied to that. So you automatically get Medicaid when you qualify for the SSI. For disability and for Medicare, you have to apply for both of those benefits. So the QMB actually allows you to keep your premium Part B rather than it getting deducted from your Social Security check. So when you retire, you have parts A, B, C, and parts A, B, and D typically, okay? Part A is hospitalization, Part B is your doctors, and Part D is your prescription coverage. Part C is Medicare Advantage plans, Part F is a supplement that you can get also for what Medicare doesn't cover. I mentioned earlier, Medicare oftentimes doesn't cover about 20%. They only cover so many days in a skilled, for a skilled need for hospitalizations and so forth. There's a set limit of days that they'll usually cover unless there's a rehospitalization. So the QMB benefit comes in, rather than them deducting, because you pay for part of you pay a premium basically, but a lot of people don't know that because it gets deducted from their check. So you never really see that unless you look at your Social Security statement, and it'll tell you on there what gets deducted from your premium Part B. Part A is fully covered by your payments into Social Security to begin with. So when you have the Part B, that amount does not get deducted. So you get to keep more money, which is beneficial for Anne in this case, right? The other thing it does is it provides Medicaid from a health insurance perspective as your backup to your Medicare. So it is your built-in supplement, okay? So if the person's not on SSI and Medicaid, plus Social Security, disability, and Medicare, where they already have the best of every world. I used to say the best of both worlds when my daughter was younger and watched Hannah Montana. But this is a way that you, again, couple every benefit possible for your child's benefit, ultimately. So now that we've discussed the trusts in general terms, and also, the different roles under the trust, and also given a benefits overview, now let's look at the terms of the document a little bit more closely. Collett, what is the language that the trustees use to determine how they can make a distribution from the trust to benefit Anne in this case?
Okay, so from a drafting perspective, we want to make sure we're including wording in the document to have all decisions made by the trustee in the trustee's sole discretion. And that's the key word, is sole discretion there. And having that, the court typically will not replace their discretion, use their discretion over a trustee's in most cases. Specifically, you want to have language that allows for the income and for principal distributions for the supplemental needs of Anne if they're not adequately covered by government benefits. And I separated the income and the principal distributions because they are made from either one or the other, one versus another, under the Florida Principal and Income Act. So with that being said, I wanted Melissa then to discuss the language in regards to how decisions are made from a trustee's point of view and why the language is important, that particular clause in the language is important, in addition to the benefits that now Anne receiving from an administrative perspective.
Yes, thank you. So I'm glad that you mentioned the language that you did there because supplemental needs for Anne, if not covered adequately by government benefits. Because, what if the language says the trustee's discretion is to make distributions where only for supplemental needs where no government benefits were being provided?
Well, what do
Um,
you typically see? What do you generally see, Melissa? And is that language problematic?
Yeah, so I do see that quite often. I review trust documents a lot from a trustee administrative perspective. And why is that a little bit inflexible? Why is that restrictive in nature? Um, and the reason for that is if Anne is receiving SSI benefits, which she should be starting after a little bit after September, and then she's going to be on Medicaid. When we talk about earlier how the trust is our guide, our roadmap as to what we can do. If the trust forbids us from doing something that we know we can do, even under benefits rules, it becomes a problem because we're prohibited by the document. So by inserting the word adequately, not being adequately provided, and instead of just saying not provided at all, that actually jives with the benefits rules. So before I mentioned the POMS, right, the Programs Operations Manual System, and in there, they actually give you 3 basic rules on how you can distribute from a special needs trust. So I want to go through those just in a little bit of detail with you by also giving examples. So with Anne receiving SSI in this instance, we can't give Anne cash directly because whether it's from a trust or from any other person, because she would have a duty, or whoever her representative payee was would have a duty to report that as income, and it will reduce her benefit dollar for dollar. So you will never see a trust document say you should give Anne in this instance any cash directly. But by having that language not adequately provided, if we know she wasn't receiving those benefits and it wouldn't jeopardize anything, we could give her cash directly. So that's why it's important to make sure that you have a full understanding of Anne, her needs, her benefits that she's on, and acting as a trustee. And that's also why the language is important. The second rule is that if you pay for things that are called in-kind support and maintenance for Anne, even from the trust, even by a parent right now, Mr. and Mrs. Smith are paying for her living, her shelter expenses because she's living with them. That's part of that $40,000 also in expenses, really on top of what they're doing for her in their own home. They're paying all the household expenses. So in-kind support and maintenance is basically food, and it's only another 8 items. So it's rent, mortgage, it's electricity, gas for the house, water for the house, garbage and sewage removal for the house. There's very specific items that are considered in-kind support and maintenance. If we pay for those items that I just mentioned, even from a special needs trust, you will reduce the SSI benefit for that person. Okay, so another area of language that I often see in the documents is that you can't reduce or diminish or replace or supplant a benefit. We don't want to see that. And why is that? From an administrative perspective, as I just mentioned, the rules, they allow you to pay for in-kind support and maintenance, but it may cause a reduction in that person's benefit. So if I have somebody that's living in their home, like Anne is here, let's say she continues to live there after Mr. and Mrs. Smith pass away, then the trust is going to be making those distributions, or we might transfer funds to an ABLE Act account to make those distributions for housing. We're going to do things in the way that's best possible to keep Anne in her home. Is it better that she gets the full $794 from SSI? Or is it okay that we reduce her benefit maybe to $500 or so, or thereabouts, and that she gets then to stay in the house if we're paying $2,000 a month for those in-kind support and maintenance payments? I think most of you that are listening to this would say, it makes sense. We have some additional money from the insurance policy in the trust now to pay for her supplemental needs. We're not adequately covered by government benefits. And by doing it that way, we've now given her the best of every world possible, because she gets to stay living in the community in her own home with potentially additional assistance through the APD waiver, the iBudget waiver. as well as having access still to some SSI to keep her Medicaid as well, at least for the next 7 years, when she should be able to go on the DAC benefit as well as Medicare 2 years after that. So that's why it's important to allow for you to have that language where it's not adequately covered, because it wouldn't be adequate to cover her needs at the $794 amount, right? The other reason for that is the fact that if you pay for those same expenses, the housing expenses or food under basic living expenses from an ABLE Act account, you also don't cause that 1/3 reduction. So we have another way of doing that as well, by transferring assets over to an ABLE Act account, and there from the ABLE Act account, having the aunt assist Anne in this instance in making her housing payments, as long as it's done within the same month that they request it. So there's a lot of different rules. The third one is if you make a distribution from a special needs trust that becomes a resource in the following month, that would disqualify you from Medicaid benefits again. Remember a few moments ago, I said you can have one vehicle, a car. It could be any kind of vehicle. So let's say Anne wanted to have, let's say we purchased a car for the parents to use for Anne, or for the aunt to use for Anne after she takes over, after the parents pass away. Well, we might want, maybe Aunt can drive herself, but maybe we want to get her a golf cart because she wants to tool around in the neighborhood where she's living and talk to other people. Well, if it's street legal, the golf cart, it'll be considered another vehicle by Medicaid, and you just knock them off because that's 2 cars in the following month. So those are 3 general rules. The only reason why I'm mentioning them to you is not so that you have an understanding of it, but to understand some of the language that will be written into the trust document. So allowing the trustee to be guided by the POMS or any Medicaid manual or other benefits rules or regulations allows the document to remain flexible, so that as Anne's needs change as life goes on, the document can change with it. Those are the basics there. I also want to just talk about, you mentioned, Collett, of course, the amendment provision being in the document, which again, just bolsters the need and the flexibility in the document to be changing if the benefits rules change in the future, or they might call them something different, or we forgot to have that being guided by the POMS or Medicaid manual in Florida. And the next thing that I often see in documents is that families also are under the misunderstanding as well that the trustee can collect and distribute the government benefits that the person is receiving, Anne in this instance. So if Anne's receiving SSI, you can't assign those benefits to the trust. So the trustee doesn't have legal authority to put those into the trust or assign them to the trust. Plus the trustee many times doesn't have a legal authority over Anne herself, right? We mentioned, again, the durable power of attorney for property, where you designate somebody that has a legal authority over you if Anne has the capacity to do that, or the guardian advocate. So, but the trustee can assist the beneficiary or his or her legal representative, or hiring a benefits specialist to assist Anne in this instance in obtaining those benefits, and it certainly should be knowledgeable about what those benefits are and how distributions can affect that. Also looking at the current living expenses, we talked a lot about, earlier about the fact that there's the $40,000 in expenses, and Collett also mentioned how with a revocable trust, if a person creates a revocable trust, the parents in this instance, Mr. and Mrs. Smith, all that means is that they retitle their assets into a name of a revocable trust. They can rip it up and revoke it at any time that they want to. They can amend it at any time they want to. They can make any changes at any time they want to the document, right? So the reason, though, it also is planning for incapacity of the parents. It might be a joint trust. So while one is incapacitated, the other one acts as a trustee for them. Assets are retitled into the name of the trust, but technically still under their own social security number. Until they become incapacitated or pass away, it becomes irrevocable at that point. And so, but during their lifetime also, because you're paying for those expenses, you want to make sure that that trust also allows for the payments to continue for Anne. But if that special needs trust is is not going to take effect until much later on after the parents die, but not during incapacity, again, you make sure that those provisions are also incorporated there in that section so that we can continue making those payments. The same in the parent's durable power of attorney for property and healthcare surrogate, allowing for those payments to continue through there with some specificity on how those should be done. So I've gone through a lot of the different rules in relation to that, and I know we're coming close to our time. We want to have questions and answers. So I just want to go through a couple other things here in the fact pattern that we have here. Somebody wants to buy a car. So if we want to buy a car for Anne, maybe she will be able to drive, right, in the future. If we wanted to do that, yes, you can do that from a special needs trust, number one. Would you necessarily title in the name of the trust? Maybe, maybe not, but the trust would at least put a lien on it if in fact there is that Anne is on SSI and we're going to put it into the aunt's name, for instance, here. And that's because we don't want to make a gift. So even though it's a third party trust, we still have to think about, have two hats on. What's good for the trust? What are the trust terms? Really three hats. And then what are the benefits, right, that she's receiving? Because it may be okay in one instance to do something in a third party trust, you can benefit other people. But from a benefits perspective, it may be that we're making a gift, and that could be a concern for Anne for her benefits. What about a house? So here we said that she's living at home. Really, again, this goes to that holistic planning and looking at what is that plan. We talked again about how the aunt lives in California. And this is why it's so important, and I can't stress this enough, to start thinking about what's going on with Anne today. What can you put into place now that will help you make sure that your plan can be carried out in the future? And I'm not trying to scare anybody here, but a lot of times I've had situations where there was a guardian mentioned in the documents. There was a plan mentioned for who the guardian would be. Nobody ever implemented it because the doctor would always talk to the family. So they never even did the less restrictive alternatives that were mentioned earlier. And they never got a guardianship in place. And lo and behold, who comes into place to try to take advantage of this one client, but the doctor's office manager in this case. So luckily, we were astute enough, and even though we were supposed to be making certain distributions to this individual, we stopped them because we knew it wasn't the right thing to do, and we petitioned to have a professional guardian appointed. So I only give you that example to say, now's the time to put it down in writing on who you want to have these roles, to talk to individuals, to explain to them what that means, to make sure they can take on those roles. Talk to your attorney about it and make sure they're well versed in this area of planning and that they are looking at that. They're not just asking you to name who you want to name and not take it a step further. I can't tell you how important that is. And then when you have those people in place, you might also want to consider just looking at getting somebody involved so that Anne is introduced early, like such as a care manager or a benefit specialist, somebody, maybe you're working, maybe she goes to, after she finishes with school, for instance, and she goes to some kind of day program or a college program, just somewhere where there's somebody already involved in her life, along with the aunt, so they start learning about things, and Anne is introduced to them also early on, so that if she is going to move to California, maybe you send her there a couple times while you're still alive. She gets to see where she would be living, and it won't be as emotionally, difficult for her when she's already going to be going through that emotional time. And the other thing I just wanted to mention is that here, Mrs. Smith may also want to retire from teaching because she no longer needs to have free tuition, right, to attend the academy school there at American Heritage. And so what if she wants to just become a care provider, paid care provider? Can she be? And the answer to the question is yes. You can also pay a parent as a caregiver. You can pay another family member as a caregiver. You just make sure as a trustee that you have support as to what that person's doing. So you want to know the duties. If it's a minor child, yes, you can still pay a parent, but you can't pay them for the typical duties of a parent in a minor situation because we all as parents have that obligation, legally speaking. But if there's something that's going to be done for that child that is not ordinary for that child, let's say at the age of, 13 or whatever, they're still not able to, they're still not continent, for example, obviously that's not your typical scenario, and that wouldn't be within the confines of regular parental duties. So here you can pay a parent as long as you substantiate it. And even if the person is receiving, and in this case, SSI, you can still pay, again, a family member as a caregiver. That wasn't always the case. And that's why I said being guided by those POMs and how those change also. The other question we often see is, can somebody come visit Anne? Can you pay for them? In a third-party trust, you can pay for somebody else to come to visit, like the aunt in this case. You can certainly pay for somebody to go with Anne somewhere as well, because it's always for her primary benefit, even if she's receiving SSI, even in a first-party special needs trust context. So hopefully we've given you quite a bit to think about today. Hopefully we've at least given you a little bit of a roadmap yourselves to, start thinking and writing down some things on the personal side of your loved one living with diverse abilities, as well as who you might think might be able to be named in that capacity, or talk to your attorney, because they can give you options on that as well. Or sometimes it's the attorney, him or herself. They have to go through certain disclosures with you in that case. But, there are people here to help, I guess is what I'm trying to say. And hopefully we were able to impart some information, both Collett and I today. And now I guess we'll turn and see if there's any questions.
Wow, ladies, has a lot of great information. I don't see anything in the Q&A right at the moment. There was one that came in earlier that was answered privately, but not pertaining to you all, the previous sessions. So that looks like that was handled. I don't see anything right now. So if anything comes in, we'll make sure that we follow the same routine, and we'll get them answered over to you guys by next Wednesday, so we can have it available to sort of like as a postscript to this whole entire thing.